Okay, hopefully that's better. I just changed the source. Okay, hopefully that's better. I just changed the source. Okay, that's why I see I had it on mute for some reason. Okay. Okay, hopefully that's better. I just changed the source. Okay, that's why I see I had it on mute for some reason. Okay. Okay, we might as well get started, and hopefully people will join the stream afterwards. Okay, hopefully that's better. I just
my name is Aaron Crane.
Okay, that's why
one of the coordinators of the Exposing Scum Landlords Project of Ontario.
For some reason.
Basically, quickly about the project.
Okay, we might as well get started.
We
and
are
will join the stream
afterwards.
YouTube channel and Facebook.
So, my name is
dedicated
Aaron Crane.
to telling.
Okay,
that's why
one of the
telling,
coordinators of
I had
the
it
Exposing Scum
on
Tenant Stories of
for some
Ontario.
reason.
Forgive me, I do have a
basically,
quickly about the project.
Okay, we might as well get started.
We are
afterwards.
channel and Facebook. My name is
dedicated
Aaron.
Okay, that's why
Tenants rights advocacy.
on
Tenant Stories of
housing
rights.
basically,
Quickly about the project.
Okay, we might as well get started.
We are after channel and my name is Aaron.
Okay, that's why
Tenants rights advocacy.
Tenant
Stories of
housing
rights.
basically, okay, hopefully that's better. So I'm still fairly new to this. This is our first actual live stream, not only just for me, but for the group, for this as well. Yeah. So there might be some kinks to work out at the beginning. So it's probably my voice over my voice. Okay, so hopefully better. Okay, a bit about myself. So yeah, our YouTube channel has react videos to things like news stories regarding housing and reactions to what's going on here in Toronto with the encampments. And the Facebook group is dedicated to sharing stories. And then we also are going to be moving into telling the stories on Facebook, either anonymously or in an interview style with tenants that have had a problem. Other things we're doing on the channel, we're currently starting a how-to on how to fill out forms and applications for the landlord-tenant board. We will be going over tenants forms to start, and then we'll go over landlord forms and what they mean for the tenant, not how to fill them out, but what they mean for the tenant, and going through the procedure of the landlord-tenant board. Okay, so we're going to get started on the slideshow right now. Okay, so today's slideshow is going to be regarding tenants' rights under the Residential Tenancies Act. Unfortunately, I won't be able to see comments because my screen is going to be full screen with the slideshow. So we're going to be doing the Q&A afterwards. So we'll start taking questions when the Q&A, when the slideshow stops and the Q&A starts. And we will go. The slideshow is probably going to be about an hour, and then the rest is going to be dedicated to Q&A. If there's, we're saying it's going to go to 9. If the questions run out before 9, we'll end. If it goes past 9, that's fine as well. Okay, so tenants' rights under the Residential Tenancies Act of 2006. So the Residential Tenancies Act. The Residential Tenancies Act, or RTA, governs the relationship between landlords and tenants in Ontario. The RTA creates the Landlord Tenant Board, or LTB. That's the website for them. I will post some of the links below after. And the Investigations and Enforcement Unit also deals with tenants issues as well as landlord issues. So, quick quiz. True or false, and then the last one is not necessarily true or false. Tenants cannot be evicted in the winter. Tenants can be evicted because they have children. Tenants can be evicted for damage to the unit because they caused it and refused to pay for it. Landlords can evict a tenant for having pets in their unit. Again, just answer these in your own head. A tenant must vacate the premise on the date mentioned on the notice of termination. So a tenant is not responsible for the noise and disturbance caused by their guests in their unit or the common areas of the building. Once the LTB makes an order terminating the tenancy for non-payment of rent, the tenant must vacate the premises. The landlord can change the locks after the LTB makes an order for termination. A tenant has 48 hours to remove your belongings after the sheriff has executed the order under the LTB. A landlord and tenant can only legally enter into one mediated settlement. So, and if a landlord issues an eviction to tenants, tenants must leave. The only situation a tenant can keep withheld 1 month's rent is. So, answers. A tenant cannot be evicted in winter. False. A tenant can be evicted anytime. Doesn't matter the weather conditions. It doesn't matter the season. Tenants can be evicted because they have children. That is false. A landlord could not discriminate based on your family status. This includes, they can't discriminate based on whether you're single or married, whether you have children, how many children you have. The only time it could be an issue is if it violates occupancy bylaws. That's the only time they can discriminate based on, if you have kids. If your unit is a small unit and you have like four children and it's based on, bylaws are based on per square foot, per person, and if your family is bigger than that bylaw, then yes, they can say we have to decline your tenancy, not because you have children, but because you have too many people that would be moving into the unit for bylaw reasons. A tenant can be evicted for damage to the unit because they caused it and refuse to repair it. Yes, you can be evicted for damaging your unit. In fact, you can be evicted whether you pay for it or not. If the damage is severe enough, yeah. Landlord can always evict a tenant for having pets in the unit. This is false. A landlord can advertise no pets, and they can decline your tenancy based on the fact that you have pets. But once you're in the unit, if you adopt an animal, or if you say have an animal and you say no, I don't have an animal, and you give it to like a friend or family for a couple of weeks to hold while you move in, and then you move your pet in, they can't. Under the Residential Tenancies Act, pets are permitted. I think later on in the slideshow there is a discussion about when a tenant can be evicted for having a pet. So when a tenant can be evicted for disturbance, interfering with reasonable enjoyment of other tenants, damaging the unit, and if another tenant has medical issues such as respiratory conditions like asthma and allergies to pet dander and shares the HVAC and is within within distance of the pet owner's unit where it would affect. If they're on the if the person suffering the allergies is on the 5th floor and you're on the 2nd floor with the pet, that is not going to really affect them up there. Tenant is not responsible for the noise and disturbance caused by the guest in the unit or in the common areas of the building. This is false. You are responsible for your guests at all times, whether they're in the common area, whether they're in your apartment, whether they're walking just to or from your apartment. You again can be evicted for something like that if it's reoccurring, or an ongoing issue. If it's one time, obviously try to work it out between you and your landlord. Once the LTB makes an order terminating the tenancy for non-payment of rent, the tenant must vacate the premise. This is partially true. You don't have to immediately leave. Usually what will happen is an 11-day standard notice will be issued, in which time if you catch up on your rent and it's not a habitual problem, the LTB will cancel the order of eviction. If you don't get caught up, then after that 11 days, the landlord, the eviction order stays. The landlord can go to the sheriff's office and request an eviction. At which time, the sheriff usually, especially right now with the eviction blitz, it's going to take a little longer than usual, but usually it takes a week or so for the sheriff to come to your door. Once the sheriff is at your door telling you to leave, you must leave. The sheriff can physically remove you from the unit. That's when you must vacate. The landlord can change the locks after the LTB makes an order of termination. Again, this is kind of true-false. They can't do it right away, but they can do it when the sheriff has you removed. A tenant has 48 hours to remove their belongings after a sheriff has executed the order under the LTB. Again, this is false. It's not 48 hours. It's 72 hours. So 3 days. So your landlord must hold your belongings for 72 hours after the sheriff has removed you from your unit. And between that 72 hours, the landlord is required to allow you access to the unit to remove your stuff. So you have to make arrangements with them. Most likely it will be at their convenience. If they're willing to hold it past that 72 hours because they can't, that's fine. But they have to allow you access at least for a couple hours. And it can only be, it can be one time, it can be multiple times, but they have to let you access that unit to remove your property. A landlord and tenant can only legally enter into one mediation settlement. No, this is false. If you're in arrears, you can be in a mediation for that. If you're in a dispute with your landlord, you can be in mediation for that. So yeah, because you can have multiple filings with the LTB for different things. So you can file for landlord harassment and landlord not repairing stuff. So those are two different filings. Um, okay. What was that last? Okay. Yeah. Okay. So the final question: when can a tenant withhold 1 month's rent? If a landlord fails to give the tenant a mailing address or a copy of the lease within 21 days of the tenancy commencing, or the tenant requesting. So you move in on the 1st, they have till the 21st to give you either a mailing address or a copy of the lease, preferably a copy of the lease so you have it. You must get a copy of your lease because it's a legal document. As a signee to that legal document, you're entitled to a copy of it. And yeah, so you can withhold, but the withholding does not mean you get to keep it. Once the landlord gives you that copy of the lease, you must pay the rent. Just one thing I did forget to mention at the top. I am not a lawyer or a paralegal involved in the law. I am a tenant advocate, so any advice given is not to be taken as legal advice. So yeah, okay. So when does the RTA apply? So the RTA applies to all residential tenancies with some exemptions, as you see down below. A tenant is a person who is supposed to pay rent in return for the right to occupy. Rent can be in kind, so it can be something like you care for the property in exchange for living rent free. Roomer, boarder, and lodger situations are included in certain circumstances. So that would be, that does not apply if a tenant lives with the owner and shares a bathroom or kitchen with the owner. A tenant shares the living space with the person they are paying rent to, who is not the owner. So this is called shared accommodations, and the RTA nor the Ontario Human Rights Code apply. They are both exempt from this situation. We will go over that, I think, in another slideshow, because that's a whole other issue that we are trying to fight to get some protections under the RTA and under the Ontario Human Rights Code. Okay, so basically the investigations unit, which is the residential housing and investigation and enforcement unit, can assist with these offenses under the RTA. Harassment, and this is by either the tenant or the landlord. Eviction without following the rules, so if the landlord does not go through the proper way of evicting, so sending the notice of eviction, filing with the board, having the board hearing, then going to the sheriff if necessary. To withhold or interfere with reasonable supply of a vital service. So they cannot cut off your hydro, they cannot cut off your water, any way of heating in the, I think, what was it, is September or October 1st to June 1st. They must keep the temperature at 21 degrees. So for a landlord to enter the rental unit, except in situations allowed by the RTA, which we will go on about further down the road. Okay, so to charge more rent than allowed under the Residential Tenancies Act. Every year, the LTB will come out with a recommendation for yearly increase. For 2020, there is a rent freeze, so no rent increases can be issued between January 1st and December 31st of 2001. That start within that period. Above guideline increases can be filed with the board application. They can be approved for 2001. unfortunately. So the RTA has issued the recommendation for 2022, which is 1.2%, which is fairly low. And that can only be instituted on January 31st, 2022. But it must be issued 90 days prior to the date of increase. So you would have to get it no later than October 1st. Failing to obey a work order from the board or the maintenance standards unit. So this would be if you've filed with the LTB for damage to the unit, say something like, let's say, black mold, and they don't take care of it. Failing to obey an order issued by the board. So with the exemption of eviction, which is dealt with through the sheriff, any other order issued by the board would fall under that. To give document containing false or misleading information to the Board of the Ministry of Affairs and Housing. So it is a crime to lie to the LTB. Obviously, they are a judicial. They are a judiciary. So yeah. Changing the locks on the door to the rental unit without the landlord's approval, without giving a copy of the new keys to the tenant. So if a landlord does that, say they're trying to evict and they just decide one day while you're out, they're going to boot you. They're going to change the locks. They can't do that. The police will break the door down for you. Failing to apply to last month's rent deposit for the last month's rent of tenancy. So yeah, the last month's rent must only be applied to last month's. It can't be used to catch up on arrears. It can't be used as a damage deposit. Failing to provide rent receipts when requested by a tenant. A landlord must provide rent receipts if requested. Either monthly or however often you pay, monthly, yearly, weekly, or you can just ask for one receipt for the year for your taxes. Did we finish there? Yes. Okay. So next. So the application process to the landlord-tenant board. So for landlords, the application process is they must send the tenant a notice. So for, let's just use non-payment of rent. So they must issue you an N4 notice. So they can issue that the day after your rent is due. And then you have a standard 14 days to pay the arrears. So then if you don't get caught up with your arrears within that 14 days, the landlord can then file an application with the board and then wait for the notification of hearing. So this would be sent, all of this would be sent, so the notice would be sent to the tenant. The application would be sent to the board and the tenant. Notification of hearing would be sent to everyone involved. Consent order prior to hearing, possibly. Mediation, possibly. So you usually there is a mediator on duty that you can request to go to mediation. Hopefully you can settle it outside the board. There is also duty counsel available to both landlords and tenants there, meaning that the local legal aid will supply a lawyer for you to talk to prior to the hearing. If you have any legal questions or like that, they will not represent you in the actual hearing, but you can have 10 minutes, half an hour to sit down with them outside of the hearing. So then you have the hearing, which the landlord can present their case and their evidence, and you can present your case, your evidence. And then there will be an order issued. It will take probably about 2 weeks to get the actual order to you, so you have that time there. And then payment, if it's a standard, you get that 11 days. If it's an outright eviction, you're late constantly, then unfortunately, then the landlord can then apply to the sheriff to have you evicted. So the tenant application process is tenant files an application. You don't have to send a notice to the landlord, because hopefully you've tried to work whatever you can out. Mediation possibly, again, hearing and order. So your obligations as a tenant: you must pay rent on or before, it says the first of the month here, but on or before your rent due date. So if you pay rent on the 1st or the 15th or the 30th, 31st, whatever, you must pay on that date. If you pay after that date, and you're always paying like on the second day, the landlord can, even though it's 1 day late all the time, can seek an eviction for repetitive late payments. So you must maintain ordinary cleanliness of the unit. So that's, make sure the floors are swept and mopped, and the dishes are, you do the dishes in a reasonable time. Keep the sinks clean, keep the showers clean, keep your room clean. No obstructions of heating, HVAC at all. No obstruction, like don't have a lot of clothes on the floor blocking access for an emergency. If to call an ambulance, make sure there's like enough space that an ambulance or emergency services can get in. You don't have to be museum tidy. Ordinarily cleanliness just means, keep it clean, keep it swept. Not to interfere with other tenants or the landlord if you live with a unit in a building or in a house, say, that's broken up into multiple units or basement apartment. Not commit illegal acts or run illegal businesses on the premises. So, don't be a meth op. So your rights under the RTA. So you have the right to the tenant information package, which is basically your lease. So leases, you don't technically have to sign a lease. What it could be is just a rental agreement. Leases usually are some sort of fixed term. So that's up to you and your landlord. So, if they don't want to keep you on a fixed term, they don't have to. You just sign a rental agreement. It's always best to get some sort of lease or rental agreement to know your legal rights, your responsibilities, landlord's rights and responsibilities. And so basically what is expected of you, what is expected of your landlord. Tenants do not have to renew their lease at the end of their fixed term. It moves automatically to month-to-month tenancy with the same terms. So this means you sign a 1-year lease. The landlord can't say, hey, your 1-year lease is up. You have to move out. So you move automatically to month-to-month. They can't increase your rent significantly after your lease ends. So with a rent increase, they can only do it every 12 consecutive months from the previous increase or the commencement of your tenancy, and they can only raise it that amount that the LTB has laid out, unless they're going to go to the LTB and apply for an above guideline increase. Above guideline increases can only happen if there's significant investment of capital into the unit. So major renovations, not just like replacing a faucet or painting or replacing a door. That's all. That's would be considered standard maintenance. So say if they're going to overhaul the kitchen, that would be something that they could apply for above guideline increase in. Landlords must give tenants their address and copy of the lease within 21 days, right to hold back rent. So again, this was one of the questions. Yes, if you don't know this, you can request a copy of it. So either from the beginning of your tenancy, they have 21 days to give it to you, or from when you request it if you didn't request it at the beginning of your tenancy. If you did not do that at the beginning of the tenancy, I suggest you do it now, because you should have a copy of that. There are several reasons why you should have a copy of that. Again, it's a legal document. It lays out your rights and responsibilities, the rules, etc. It is also proof of residency if your landlord decides that they want to evict you without going through the board and they change the locks, etc. Save it to, scan it, save it to a cloud, copy it, put copies in your car, in your bag that you carry around, purse, whatever. Give a copy of it to a very close friend or relative who lives nearby. That way, if that ever happens, you can grab it from them. When you call the cops, there's your proof of residency, and they will let you into the apartment. Tenants' rights under the RTA. Okay, so quickly, if anyone new has joined, welcome. We're just doing the slideshow. We will be re-uploading this and probably doing a rebroadcast very soon. So if you missed the first part of it, don't worry. You can see that on YouTube. The question and answer will start after the slideshow. Please hold questions till that point. And I think that's all I have to mention. So just welcome to anyone new. I can't actually see what's going on the Facebook page, as my screen has the slideshow in full screen mode. I'm sorting out bugs on how to do live streams. Haven't done it before, so bear with me. So discrimination under the RTA. The Ontario Human Rights Code applies in the area of accommodations, again with certain exemptions. It is illegal to discriminate because of race, ancestry, where you're from, color of your skin, your citizenship status, your religion, your sex, age, marital status, meaning if you're single, married, have children, your receipt of public assistance or source of income, other things that can apply there. Again, source of income. A landlord cannot ask for your source of income, cannot ask for a letter of reference from an employer or anything like that. They can ask for verification of income, and that's up to the tenant as how they're going to provide that, either with pay stubs, bank statements. Redact your bank statements if you're doing that. Only take out all your private information, redact your spending, and redact where you're getting your deposits from. You can also supply your benefits statement. Any way you want to. That's up to you. Obviously, whatever way you do it, is going to show your source of income, but they cannot discriminate you based on that. Of course, they do, unfortunately, and they just lie about it. So other things they can't, your gender identity, your gender expression. So if you're trans, if you're non-binary, if you belong to the gender diverse communities, however you identify, they can't. How you present, how you dress, they can't discriminate on that. They can't discriminate on whether you identify as part of the queer community, LGBT, whatever. So landlords can, however, refuse to rent to tenants based on bad credit ratings, rental history, and poor references. If you're going to supply a reference, make sure that they're not going to bad talk you. So basically, when it comes to references, a reference can only discuss your tenancy. If you have a personal history with them, with a previous tenant or previous landlord, say, romantic, we lived with the person. Friends, if you just stayed with a friend for a bit, they can't discuss your actual friendship, etc. Okay, so deposits under the RTA. Key deposits are legal, but can only be no more than the cost of replacing the key, fob card, etc. This means that they can't charge you a $200 deposit for your keys. So if it costs $5 to replace a key, they can only charge you $5. For fobs and cards, it's more expensive. I know the one time I lived in a building with fob access, it was $75 per fob, so they can charge you per key per fob. Damage deposits are illegal. They cannot ask you for a damage deposit or any other deposit except for last month's rent. Landlords may collect last month's rent. This is to be used again for last month's rent. Not returned to the unit after they move out. Not kept as a security or damage deposit, or even applied to a missed month's rent. Tenants are entitled to a set amount of interest each year. So on that last month's rent, they must pay you interest. It's usually it's equivalent to the increase. You can either do it as a payout at the end of your tenancy, at the end of the years, they have to pay you that, or they can apply that into last month's rent so that you don't have to top up last month's rent for any rent increases that have occurred. Rent increases. Landlord cannot increase the rent because a tenant has somebody else staying with them or because they have a pet. They can't say, oh, you have your mom has moved in with you, I'm going to have to charge you $100 more a month. Pets, they can't increase either. They can't charge you rent based on occupancy. They can't say, okay, so the unit is $1,100 for one person, $1,300 for two, etc. It has to be set one or more persons to the occupancy bylaw. Rent can only be increased according to the guideline. So again, for 2020, there is a rent freeze, and for 2021, it's 1.2%. Rent increases must be given on the N1 form with 90 days written notice. They can't just handwrite you or text you saying, your rent's going up. They must put it on the proper LTB form, which is the N1, I believe. Rent can only go up one. It's either an N1 or N2. Rent can only go up every 12 consecutive months. Illegal rent increases or illegal charges become legal after 1 year. So if you have been charged more than that year's percentage, and you can always look that up, you can always just Google rent increase for percentage for year. And if they was illegal, it's not going to be any more than $100 most of the time. If they're increasing it by 150, that's 99% a illegal rent increase, and you can file with the landlord-tenant board to get the difference back. But you only have 1 year to do so. If you do not file a complaint, you lose that opportunity, and not only that, the rent increase, that illegal rent increase, then becomes legal, and you can't fight it. Okay, so your maintenance. Landlords are responsible for maintaining the rental unit in a good state of repair. So, this includes the unit itself, appliances, fixtures. If your fridge breaks down, they must replace it. If your stove breaks down, they must replace it. Usually, most places you're going to move into, the appliances are going to obviously be used by the past tenants. And obviously, things break down. It is not your responsibility to pay for it unless the damage was caused by you. Say you leave something in the oven too long, fire starts, that's your responsibility. For some reason, you damage it purposely, that's on you. Same with the unit itself. Any damage that's done by the tenant, except for what's considered normal wear and tear. Things like putting holes in the walls for to hang stuff on. That's considered regular wear and tear. If you want to avoid a fight with the landlord, just quickly get a bit of spackle and just fill in the holes. That's all you have to do. You don't have to repaint or anything unless you've repainted with the permission of the landlord under the proviso that you must return it to its original color. So it does not matter if the tenants were aware of any problems before they moved in. So you move in, the faucet is leaking or the drain is leaking. Make notes of it. So my advice, when you're applied to have approval, before you move anything into your unit, do a walkthrough. Grab a clipboard, grab a piece of paper and a pen, walk through and note any damages done, any broken appliances, just any issues. And then hand it to the landlord. That's written notice of stuff that needs to be repaired, and they must repair it. And take pictures. Take pictures. If they fail to do it, or if I'm having this problem right now with a previous landlord. My unit was, well, it was basically a slum unit. And when I left, we left it in better condition than we found it, but there was damage. There was a broken window when we moved in. Tiles were up. This was all said, oh, well, fix it. Now they're charged because I don't have proof that it occurred prior to us moving in. He now wants us to pay for renovating the entire unit. So don't let this happen to you. Get proof that existed before you moved in. So photos, make notes to hand to your landlord. If they don't do the repairs, file with the LTB. They will force them into doing it. There is no such thing as renting a place as is. Again, they can't rent. If there's damage and they say as is, they still have to fix it. It's not your responsibility to fix anything, but it might be your responsibility to pay for damage that you may have purposely caused or accidentally caused, such as, say, the oven fire. You cannot be evicted because you asked the landlords to do repairs they're responsible for. Yeah. So your right to privacy. General rule for the landlord cannot enter the rental unit. There are exemptions. Landlord can enter anytime if there's an emergency or if the tenant agrees to let them in. So an emergency under the Residential Tenancies Act would be something like a water leak, leaky faucet, gas leak, electrical problem, suspicion of fire or something like that. And then they can enter your unit without notice. They can knock on your door and just, whether you're home or not, whether you answer or not, enter. Unless your landlord has sent you 24 hours written notice with a valid excuse, do not let them in. If they harass you, don't let them in. File for harassment if it constantly is happening. Because once you say, all right, fine, come in, that's legal. That's now a legal entry. So yeah, even if you're bullied into it, even if they shove you aside, well, if they shove you aside, then yeah, that's illegal entry. But if you say yes in any way, that's legal. So the landlord must give 24 hours written notice before they can enter the premises, and they can only enter between 8 a.m. and 8 p.m. But this does not mean that they can say, I'm going to enter between 8 and 8. They must give some sort of reasonable time frame. The LTB is basically recommended between 2 and 4 hours is acceptable. So they can enter to make repairs to the unit to allow mortgagees, purchasers, lenders, insurers, etc. to view the unit. For inspection by themselves, by an engineer, architect, similar profession under the conversion under the Condominium Act. To inspect the unit for any reasonable reason allowed in the tenancy agreement. So a notice must be in writing via one of the ways that's been agreed on or has been established as agreed on in the past, or as a regular form of communication. So for this notice, it can be text, it can be email, it can be a physical note dropped off. It must be 24 hours. So if they say they're coming in between 4 p.m. and 6 p.m., they can't come at 3:45. They can't come at 6:15. Yeah, 24 hours means 24 hours. If they give a specific time, then they can't come before that, and you have to allow for a reasonable. So if they say they're coming for 4:30, you have to allow for some sort of reasonable time. In case there's traffic or whatever. You can refuse before the time that they sent you. It must include a valid reason why they're coming in. It can't be, I'm just, hey, tenant, I'm coming at 4:30 to enter the unit. They have to say, I'm coming in to do a quick repair on yada yada, or I'm coming in for a quick inspection. I'm bringing an insurance adjuster, or something like that. Okay. So regarding pets, I'm going to go back quickly to privacy. Under the Privacy Protections Act, a landlord cannot discuss your rental situation, your rental agreement with another tenant, with family, with friends. The only time that they can do it is, say, with their legal advisor, lawyer, paralegal, etc., or somebody within their employ, say the superintendent, a secretary that works for them, a rental agent, etc. They cannot post notices on your doors that are that are private, such as an for notice, etc. If they do so, it must be concealed so that other tenants or other individuals cannot read it. So the pets. No pets rules are void. So even if it's in the lease, it's void. Any provisions, rules, etc. in your lease that are illegal under the Residential Tenancies Act, the Human Rights Code, or any other legal any other law, are void. You cannot sign your rights away. A landlord cannot stop a tenant from having a pet. A landlord may refuse to rent to a tenant if they have a pet. So yes, they can ask you if you have a pet, and they can, if you answer yes, file your application in the G file, garbage. Tenants may be evicted if the pet is dangerous or causes severe allergic reactions to other tenants. So yeah. So pet is interfering with reasonable enjoyment of other tenants. They're loud, they're barking, they're aggressive with other tenants' pets. They've caused damage to the unit or the common area. And again, allergic reactions. If a tenant has an allergic reaction, they obviously are allergic, but usually it would have to be proven with something like a doctor's note, and then, yeah. Terminating the tenancy. So a tenant who rents month to month or is on a month must give 60 days written notice if they're going to move out, or even if they do not have a lease. Move out date has to be the last day of the rental period, not the first day. So basically, if you're under a lease still, most of the time a landlord will let you out of the lease. They don't want to bother, but you can reassign your lease, or it's sorry, how do I put this? You can reassign the lease to somebody that you find, but most of the time, most reasonable landlords will let you out of your lease because they obviously don't want to go through the legal crap that they're going to have to go through. You know, if suddenly you lose your employment or lose your source of income, they're obviously not going to want a tenant who's not going to be able to pay the rent, and then not have a tenant who they're going to have to go through, pay filing fees and possibly legal fees for an eviction. So most of the time, yeah. Unfortunately, if you are under a lease, you are responsible for the term of that lease. If you move out, you could be required to pay off the remainder. Reassigning your lease is a good option as well. If you can find somebody, a landlord cannot reasonably refuse this. They can refuse for stuff like, the person you find won't be able to cover the rent, etc. For evictions, it is illegal for a landlord to change the locks or interfere with access to the renter unit unless the sheriff has transferred possession to the unit to the landlord. So again, they can't change it just on a whim. They can't change it after they've got the order. They can only change it after the sheriff has, removed you from the unit. Then they can, even with you just standing right there, change it. Sheriff can only transfer possession of a rental unit if there's been an order from the landlord-tenant board. So a landlord must show that order. The board can only issue an order if the landlord has filed an eviction application to evict. So, yeah, the LTB is not a psychic entity. So reasons for eviction. So mid-tenancy evictions can happen for arrears of rent, can result from failure to report change in income or other. This can result from failure to report change in income. This last after the dash is related to rent geared to income housing. So yeah, you can be evicted if your income changes and you don't report it. Rent geared to income partially falls under the RTA and partially doesn't. Substantial interference. Again, so if you're interfering with the reasonable enjoyment of other people in the complex. Impairing the safety of people. Again, this would be something like if you're blocking off the HVAC, if you have electric heaters and you've put stuff up against them. So damage to the unit. So, you're having a really bad day and you just have a rage attack and punch a hole in the wall, you can be evicted for that. Illegal acts, so buying, selling, producing any illegal narcotic or controlled narcotic. This obviously now excludes marijuana and I think it's 3 plants. You're allowed to have 3 plants for personal use. And obviously you're allowed to consume unless there's a no smoking rule in the building. No smoking is perfectly legal to be required in a building, even in the unit. Misrepresentation of income. So again, you claim you're making more than you are and it won't actually cover the rent. Overcrowding, again, this is if you have long-term guests or family who stay, and it violates the bylaws for occupancy. So at the end of a tenancy, you can be evicted for persistent late payment of rent. Landlord's own use, this is N12 filing, and it can only be for specific people, immediate family, or the landlord themselves, which means landlord, landlord's spouse, if they live in different places for some reason, sibling, and parent. Not the landlord's, or no, not sibling, sorry, children. So landlord, landlord's spouse, landlord's children, parent, or caretaker of any of those. They cannot evict for use of their cousins, their siblings, extended family, or under purchaser's own use. So if your landlord is selling your house, or selling the, say you're renting a house, the house, a purchaser automatically inherits you as a tenant unless they're going to be either demolishing or doing serious renovations, which is an N13, or an N12 for their own use, or again for anyone on that N12. Just going over quickly, oh no, I have it at the end. Okay, so personal possessions after tenancy ends. So this applies to if you've been evicted and had the sheriff had to come. Access to the unit to retrieve possessions for 72 hours after the enforcement by sheriff. So yeah, you have 72 hours to make arrangements with your landlord. The landlord must allow you access at least one time to get your stuff out within that 72 hours, or an agreed upon time. So, you know, they can't do it within that 72 hours, and they say, okay, so you've got Monday, Tuesday, Wednesday as the 72 hours, and they say, I can make arrangements to do it Thursday, Friday, or whatever. But if they do agree to that, they must keep your possessions. They can't move it out. So a landlord cannot hold on to possessions because the tenant owes rent. So yeah, you move out. You have a $4,000 stereo home theater system. They can't say, okay, well, we're keeping that to pay your back rent. They cannot take stuff. They cannot pawn stuff. If they do, that's theft, and they must reimburse you for whatever they stole. So the steps to eviction. So step one, the landlord must give notice of termination. In most circumstances, 99.9999 of all circumstances. And I can't think of a single one that you wouldn't give notice unless it's, yeah. No, I can't think of one. Notice of termination set out a termination date. So an N4, the termination date is 14 days past the date issued. Technically, that 14 days. That 15th day is your supposed move out date. You don't have to move on that date. You can wait for a hearing. Okay? Tenants do not have to leave by the termination date in the notice. So, basics. Grounds. A landlord must have grounds specified in the Residential Tenancies Act to evict a tenant. So we went over that earlier. Procedure. Landlord must follow a procedure specified by the Residential Tenancies Act to evict a tenant. Landlords cannot change the lock, turn off heat, utilities, or try to force tenants out without an order from the board. In fact, they cannot, even with one. They can only go to the sheriff's office. If a landlord withholds vital services, you can take them to the board. You can file against them. Eviction is a serious matter and is considered a remedy of last resort. So the RTA provides protection from unlawful evictions. In many cases, tenants can prevent evictions. Yeah. So pay up your arrears. Don't be habitually late with the rent. Stuff like that. So step 1, early termination for a cause. Non-payment of rent, which is an N4, and the application is an L1. Damage to the unit or common areas. So that's N5, L2. So you would receive the notice. As a tenant, you would receive the notice. The application goes to the board. You would receive a copy of that, but that's what goes to the board, not the notice. Overcrowding, which is an N5, L2 again. Misrepresentation of income for subsidized housing tenants. That's an N6, L2. Illegal acts, trade, business, occupation. So, like I said, drugs. Unfortunately, stuff like in-person sex work, or, and I don't like to use these words because sex workers are workers, and sex work should be decriminalized and legalized, but prostitution, substantial interference with reasonable enjoyment or unlawful right, privilege of interest, which is an N7, L2, and impaired safety, which is an N7, L2. So again, impaired safety would be blocking off HVAC, heating, stuff that might cause fires, etc. 2, early termination for cause, fast track. So this is stuff that could be, usually a board hearing would be scheduled within 14 days. Usually a lot sooner. So the illegal business involving drugs, which would be an N6, L2. Willful and undue damage, N7, L2. Use inconsistence with the residential premises that cause likely to cause significant damage. So again, that would be something like a grow op or a meth lab. Serious impairment of safety. So that would be hoarding, extreme messes, just stuff like that. Again, stuff like blocking off heating and the possibility of fires with, say, electrical, if you've got it right bulked off with something that might be flammable. Step 2A, voidable notices. So this is stuff that you can make good and save your tenancy. Tenants can void or cancel the notice of termination by paying arrears owing under the notice within 14 days of receiving that notice. Stopping behaviors outlined in the notice with new exemptions. See next slide. Fixing damage or paying for it to be fixed within 7 days. Some notices obviously cannot be canceled. Step B, non-voidable fast-track evictions. So these are ones that you can't save your tenancy if you get the eviction. A tenant does not have the option to void or cancel with illegal acts, substantial interference where the owner lives in the complex and where the complex has 3 or less units. That's the new one. Willful or undue damage to the unit in a way which might lead to extreme damage. Example, grow ops. Sometimes you can get a conditional order, say for something like if you're hoarding, if you clean up the apartment and safety issues are taken care of, then you can save your tenancy. Usually what will happen is you'll be given a a conditional order, which is usually 12 months. So you must keep your unit in livable conditions for those 12 months and beyond, obviously, but keep it in livable condition for 12 months. If unfortunately you fail to do that, the landlord can automatically file for eviction, and that will become non-voidable. So fast-track evictions in the case willful damage, using the residential unit in a manner that is inconsistent, impaired safety. The board has jurisdiction to order a tenant evicted even before the termination date of the notice. So yeah, if the damage is really bad, if the hoarding is really bad, if the mess is really bad, So step 3, landlord must apply to the landlord and tenant board for an eviction hearing. The landlord must give notice of hearing to the tenant. So you usually, as a tenant, should receive a notice of hearing as well. But if you don't, the landlord must give you it anyway, either way, to say that they did. And then, of course, hearings now are being held over Zoom, and that will be carrying over past COVID. Unfortunately, I have a lot of issues with that. The most important change under the RTA is that now every tenant will have a hearing. A problem with the RTA is that it does not provide for a set aside motion. I'm not familiar with set aside motions because I haven't had to deal with one. Step 4, agreement to settle. So this would be mediation. If parties can agree to a payment plan for arrears owing, they can file that settlement with the LTB, who must issue the consent order based on the agreement. Consent orders can only include payments of arrears, NSF charges, and rent and fees. Consent order cannot include a termination of the tenancy. So if you agree to this, there's no agreement to end the tenancy. If you fail to abide by the agreement, the landlord must reapply for eviction. Unfortunately, right now, there's a lot of bullying into payment plans. And with the new, C-124 that Ford issued, there's a lot of problems. We'll probably go more in depth in that on another stream, or just in another video. So step 5, the hearing date. So but prior to the hearing, you might request or be asked if you'd be open to going to mediation. So you, as a tenant, may ask for mediation on the hearing day. If the landlord agrees, there will be mediation. Of course, if they don't agree, there's no mediation, because if a landlord doesn't agree to mediation, they're not going to agree to anything within the mediation. A tenant can try to work out a payment plan or other solution with the landlord in mediation. Mediation agreement can include a termination of the tenancy. And landlord can obviously request mediation, and the tenant can or does not have to agree. So the actual hearing, before the hearing, you can also request to talk to duty counsel, who is usually a lawyer from one of the local legal aid clinics, who will sit down with you for a short time, usually 15-20 minutes or so, to answer any legal questions, or guide you on how things will go, or guide you where you should be focusing if you're questioning, because you can be your own legal representative at the hearing. The duty counsel will not represent you in the hearing. My advice is get a legal aid, get a lawyer, call legal aid if you can't afford a lawyer. Usually they will try their best to assist you as much as they can. Sometimes they won't be able to represent you at the hearing, but they can help fill out forms, answer questions, etc. So the hearing. So if you've paid your rent, you must prove it's been paid. So make sure you get a receipt. Have a canceled check, bank records showing an e-transfer or whatever. Most of the time now, apps, if you're paying by check, they will usually send you a picture of your canceled check that you can pull up. You just scroll through, and click on the check that has gone through, and you can see that. So yeah, keep records of rents paid. If you're paying in increments, get a receipt for those increments. Pay all rent owing and the application fee. Usually, I think it's about $59. I'm sorry, I'm not gonna actually say, because I'm not 100% sure. That sounds low to me now. So you must pay for the application fee before hearing day, or prove tenant did not do what the landlord claims witness documentation. Ask for relief against eviction. The board can order a payment plan or make other conditions in the order if not unfair in the circumstances. So they will take into considerations like if you've lost your employment, you're gone on assistances, or if you're on assistance, if you're on ODSP, OW, etc. They can take that into consideration when ruling. So step 5, the hearing, the adjudicator's consideration, or the member. So most of the time, when addressing the member, the adjudicator, it will be either some will want your honor, some will just accept Mr. or Mrs. Ms. member, or their name, their last name, etc. The board is now required to review all circumstances and consider whether or not to grant the eviction. So again, you present your side, landlord presents their side, and everything must be taken into consideration. Unlike under the TPA, I think that's Tenant Protection Act or something like that, the board may now hear set-off arguments from tenants about their own issues at eviction hearings. So this would be bringing up if the landlord has not done repairs, replaced appliances, is constantly harassing you, sending notices of entry, excessive notice of entry, etc. Step 5, okay, so the landlord cannot grant the eviction if the tenant can prove the landlord is in breach of its obligations. So again, bringing up those issues such as harassment, failure to repair, replace. The reason for the application is that the tenant complained to the government authority about a landlord's violation of health, safety, and housing or maintenance standards. So if you can prove that your landlord has filed in retaliation against you for reporting them for not doing their job as the landlord, the board can tear up the eviction and say no, and they may even fine the landlord, and you may even be able to file for abatement, so of the rent during the repair being reported and being done. Once they get around to doing it, you can ask for financial compensation as well. The reason for the application is that the tenant has attempted to enforce his or her legal rights. Again, See the last, this is basically this last point repeated. The reason for the application is that the tenant is a member of a tenants association or attempting to organize one. Yeah, you are legally allowed to organize in your building with other tenants to get things done that the landlord or property management group or whoever is not doing. Fighting against illegal rent increases, fighting against above guideline rent increases. You are allowed to organize. You're allowed to be a member. The landlord can prevent you from meeting on the premises, but they cannot prevent you from forming a tenants alliance, tenants union. In fact, I would suggest if you live in a building, talk to your neighbors and start a tenants union. Just like with collective bargaining for a job and work-related unions, you're stronger together than as an individual. Step 5, determining arrears at the hearing. Under the RTA, the landlord and tenant board shall not make determinations or review decisions concerning eligibility for rent guarantee income or... So, yeah. The board cannot deal with rent guarantee income units and tenants. There's still no independent review of a subsidiary revocation. After the hearing, if a tenant is unhappy with the decision made by the board, the tenant has 30 days to review. Ask the board to review the decision internally. Serious errors of law or in material fact. To appeal, go to a higher court. If you're appealing, again, call legal aid. They can help you go through it. This can happen for board bias or member bias, because especially right now, the Ford government has appointed a lot of very pro-tenant union landlords. I think I have a slide in here talking about them. The tenant may void an eviction order for arrears by paying the amount ordered before the termination date in the order. When a tenant has been ordered to pay arrears, tenant may avoid eviction by paying all monies owed plus cost of the landlord anytime before the sheriff attends. The provision can only be used once in any tenancy. So, yeah, that second one. After enforcement of eviction, the RTA extends time to reclaim possessions of up to 72 hours from time eviction order is enforced. Again, we've talked about situation. Landlord must provide tenant access between 8 and 8. RTA gives board express jurisdiction to hear tenant's application respecting landlord's failure to provide access. So you can't file for if the landlord denied you access. Hearing, the tenant can provide, in their cases, oral tenancy of themselves or other tenants, oral or written tenancy testimony of witnesses, pictures, videos, expert reports, receipts, canceled checks, any written agreements or other documentation papers that support the tenant's claim. Okay, so quickly go here. When collecting evidence, as soon as your landlord starts even hinting at something like an eviction or starts harassing you, put a call recorder on your phone. Put a voice recorder on your phone. Ontario has a one-party consent law, which means that as long as the person recording is part of the conversation, they do not have an obligation to inform other parties that they are recording, and they can record the conversation. Screenshot text messages, save emails, save voicemails, transfer them to your computer by any means necessary, even if you have to hold it up to a mic and record it through Audacity or other sound editing software. Keep all emails, letters written. If you feel comfortable or if you can afford it, put up security cameras in your unit. You have the right to record in your public space, in your private space. Same thing with audio. You can record in your private space. It's your area. You cannot, however, put recording devices in public or common areas of buildings or units. The adjudicator issues an order after the hearing, can be issued the same day verbally, following a brief written order, followed by a written order. So basically, the member can say, "Okay, I've made my decision. I don't have to think on it or anything. You haven't paid your rent, so unfortunately, I am going to grant the eviction order." But then they must follow it up with a written order. Parties will receive written orders in the mail. You will receive it in the mail and possibly via email as well. Parties can ask the adjudicator to give detailed reasons for their order. The adjudicator may dismiss the application of the landlord, allow the application of the landlord, give time for the tenant to vacate, give tenant time to pay arrears. So give time to vacate. If you request a reasonable amount of time, an extra 30 days, an extra 15 days, they may grant it. Refuse to grant an eviction even if there are grounds for an eviction. Order the landlord to do the repairs. Pass any order that the tribunal feels is fair and just in the circumstances. And the validity of the order is usually 6 months from the date. To prevent an order, a tenant can pay the amount specified. I think this is just a repeat. After the order is enforced, pay amount specified plus check any bounced fees, rent, and additional rent before the sheriff enforces, plus sheriff fees if they've already been paid, and filing fees with the board. To prevent eviction, the tenant can, before the order, comply with the conditions as stated on or by the date specified. For example, reduce the number of occupants in the case of overcrowding, pay the landlord and the cost of repair for the cost of repair or repair damaged, remove the pet causing allergies or interference with reasonable enjoyment of other tenants, pay the rent on the first of the month for the time period ordered. So the enforcement order, once an eviction order is issued by the LTB, the landlord can enforce the eviction by filing the order with the sheriff. This means the sheriff will come and change the locks. The landlord must file the order with the sheriff while the order is valid. Tenants have 72 hours from the time eviction is enforced. Locks are changed to reclaim their possession. The landlord must provide tenants access between 8 and 8. Tenants can apply to the board if they do not grant access. So a review or appeal, if either the landlord or tenant is unhappy with the decision made by the board, they have 30 days to review and ask the board for a decision internally, which is with serious error in law or material fact, or the tenant was not able to participate in the hearing. So this is one I'm going through right now. In February, in late last year, I filed harassment against my landlord. I got a hearing in February that I did not receive the notice for because it went to my scam and spam inbox, and I missed. Appealed, had a hearing for that. Appeal was granted another hearing, and now I'm waiting on another actual hearing for the issue. Appeal to go to court where there's an error in law only. Client should get legal advice immediately. Do not wait until the last day to get advice. Quick note on filing fees. If the person filing can appeal for a fee waiver if they're in, if they have low income or are on assistance. So yeah, you can. Reality for tenants facing eviction for non-payment at the board. There is no limitation in the RTA as to whether the landlord can apply for arrears. So yeah, if you're 1 month, if you're 6 months, if you're a year, they can apply for that full amount. If a tenant does owe money, tenant must be able to pay off within 7 to 11 days of the hearing. So yeah. Again, you can work things out, make a payment plan, etc. Tenant, so applications that you can file as a tenant. So for harassment, illegal lockout, that's lock changes, denial of vital services, heating, water, air, heating, water, air, and electricity, unless you are responsible for the payment and your services have been cut off because you're behind in the payment. If you're responsible and the landlord still cuts you off just to try and enforce you, that's illegal still. Interference with reasonable enjoyment, currently T2. Obviously, form numbers can change at any time. Repair and maintenance, T6. Rebate of illegal rent, increase or deposits, that's a T1. Limitations, you have 1 year from the incident. There are some extensions. I think it's, in fact, going up to 2 years for most things. Stuff like, evidence on tenants. So you can provide, again, expert report witnesses, photographs, documents, and letters. So again, what I just said, save everything, record every interaction with your tenant, with your landlord or landlord representative, even landlord's friends, because sometimes loose lips might, let it slip that, that they issued an N12 and they're just going to re-rent the place. Tenants must prove the allegations. T6, T2 and T6 have tip sheets. The ACTO, ACTO is a Toronto tenants union, or a Toronto tenants advocacy group as well. So top 5 problems with the RTA, there's lack of set-aside provision. Tenant is now responsible for the repair of undue damage. Lack of protections for family members who are not named in the agreement. So who are not people not on the lease or rental application. The board will not take jurisdiction over calculation of rent subsidies. So again, that's for rent geared to income. Recent appointments to the LTB by the 4 government conservatives have swayed the board heavily in favor of the landlord. Common tenant myths. Okay, so this is the true or false that was up earlier. Can't get evicted in winter. Yes, you can. Can't hold back rent if the landlord doesn't make. I can hold back rent if the landlord doesn't make repairs. You cannot do this, but you can make an application to the board to pay in trust to the board the rent, and the landlord will not receive the rent till the repairs are done. Then it will be released to them. And that means you could pay the board, they will put it in an account set aside, and no matter how long it takes, you can pay your rent to the board. So if it takes 6 months, you can pay the 6 months rent to the board, and the landlord won't see a dime of it until it's taken care of. This is in very, very, very special circumstances. It's been a long time since you requested it, and the repairs haven't been made. So I'm not allowed to have guests, children, and pets in my unit, including overnight guests or long-term guests. Yes, you are. You can even have long-term paying guests, as long as it doesn't violate occupancy bylaws. The landlord can charge me extra if I have guests. No, they cannot. It is a tenant's responsibility for yard maintenance and keeping walkway ice and snow free and clear a driveway. That's just false. External maintenance, lawn maintenance, clearing driveways, clearing walkways. That is the responsibility of the landlord. This is a very common myth. Tenants just assume that they are responsible for it. If the landlord wants to make the tenant responsible, there must be a separate agreement to do this, and there must be some sort of compensation. This doesn't mean a reduction in rent. This does mean being paid for it, because you're technically a lawn maintenance contractor at that point as a tenant. Enforcing tenants' rights under the RTA tenant applications, you get the 1 year period. Various tenants' applications include tenants' rights and maintenance. Defenses to arrears application. A tenant may raise in a landlord's arrears and eviction application any matter that could be raised in a tenant's application. Again, our maintenance, disrepair, landlord misconduct, harassment, etc. So notice about N11 forms. So an N11 is a agreement to end the tenancies between tenant and landlord. If you have been sent an eviction notice or no hearing and you do not want to move, do not sign an N11 or any other documents. If you intend on filing or waiting for a board hearing with the LTB for an eviction order, any eviction matter, do not sign an N11. That means you are not. That means you're not consenting to the eviction and intend to move out by the stated contest. Okay, so an N11 means you are not going to the board, that you're not contesting the eviction and intend to move out by the stated date on the N11. So if you sign this, you're signing away your rights to a hearing, no matter if you know what you're signing or not. So, and do not sign any other forms given to you by the landlord. Just take them, thank them, and state, I'll wait for the official notice of hearing and hearing date. So, regarding N12s, notice about an N12 to evict because the landlord or a purchaser or a family member requires the rental unit. So, this issuing an N12 is a common tactic in recent years, with rent skyrocketing for the landlords to issue bad faith N12s stating they or somebody listed on the N12 will be moving in. So then once the original tenant, you, move out, the landlord will relist the unit and dramatically increase the rent well above what they would be able to do with the rent with the tenant still living in the unit. This is called a bad faith eviction, and the landlord can get in a lot of trouble for it. They can face fines, and you can file for compensation. You can, in fact, I believe it's get 1 year rent. They can pay. They will have to pay you 1 year's rent. A tenant has the legal right to fight all evictions, including an N12. This includes even if you believe that the N12 is in good faith. Because waiting for the hearing will give you more time to look for a place. If a tenant believes that the N12 is in bad faith, they can immediately begin collecting evidence. Save all communications with the landlord, emails, texts, handwritten or printed notices. A tenant should immediately put a voice and call recorder on their phones. On their phones or numbers that the landlord has. So, if they have your cell phone, your spouses, your kids, put call recorders and voice recorders on there. In Ontario, we have what's called the one-party consent law, meaning that as long as the person recording the conversation is party privy to the call conversation, they can do so without informing or getting consent from other parties. Keep an eye out for online ads to rent your unit out after your move-out date. Just casually keep an eye on Kijiji, and Facebook and stuff like that. The landlord or person listed on the N12 as moving in must move in right away and live in the unit for 12 consecutive months, and only that person listed on the N12. So that doesn't mean, let me clarify that. So they must move in for 12 consecutive months and live there. They have to move in right away. Something like a paint job can be done, but if they're renovating, they should have issued an N13, not an N12, even if a family member or they are moving in after the renovations. And the only person that can move in is that person listed. So that means that they listed the landlord listed their mom or their parents moving in, and instead they move their children in. That's what that means. It doesn't mean that if they said the parents are moving in, they can move in anyone they want with them. Okay, keep an eye out for suspicious behavior, such as having showings of your apartment, a suspicious number of people being paraded through your property under the guise of being contractors, assessors, mortgagees, insurance reps, etc. If they've issued you an N12, they shouldn't be showing your apartment to prospective tenants. That's a big red flag, and file. Set up a cheap security cam system in your apartment when you're not home. When you are record visits. Again, this is your home. You can take video and audio of your home without telling people, except in common or public areas. As a tenant, you have the right to a hearing even if you believe the notice is legitimate and intend to move out. It could buy you time to find a new place. So it usually takes a couple of months for a hearing. So instead of the 30 days, you now have 90 days. Notice about N13, notice to evict because of landlord, and we're almost done. Wants to demolish the rental unit, repair, or convert it to another use. So an N13 means the landlord intends to do significant renovations that would seriously impact the life, reasonable enjoyment, and safety of the tenant. Intends to demolish, meaning to the ground, or reallocate the unit for other uses. So they want to turn it into a condo. They want to turn it into an office, some sort of retail environment, etc. Again, N13 are being used to evict tenants to do renovictions and then re-rent at a higher rent. The problem with an N13 eviction is the tenant must, after the renos are done, be given the right to first refusal, meaning that the tenant must be offered the unit back at the same rent if the landlord has not issued a rent increase within the past 12 months. From the last date of issue, they can issue a standard rent increase. With the rent freeze being 2020, they can't do it for this year, but they can issue for January 1st, 2021 with 90 days of increase. But they can apply for above-line increase with proof that they invested significant capital in the renovations. Okay, and that's it. So the Community Legal Center website, the Landlord Tenant Board website, Clio's website, which is another tenants rights and legal rights group. ACTO, which is the Tenants Rights Ontario. Hastings Housing, I believe, is assistance with sheltering, and then landlordsselfhelp.com. That's aimed at landlords, but it's always good. This landlord's self-help site is fairly impartial and neutral, and does advocate for tenants' rights. So you can also look there for your rights, or to see how it's being explained to tenants. So quickly about shared accommodations. This is the last of it. What is a shared accommodation? A shared accommodation is when tenants, board or roommate share space such as a washroom or key or with the kitchen with the landlord or the person they're paying rent to. These rentals are not covered by the Residential Tenancies Act at all, nor are the protected classes under the Ontario Human Rights Code, meaning they can discriminate against you in housing. They can discriminate based on religion, your diet, your sex, your gender expression, gender identity, skin color, where you're from, no matter what. They can say whether you're male or female. Meaning landlord in the situation is free to discriminate against religion, skin color, place of origin, income status, income source, sex, gender identity, gender expression, sexuality, etc. There are also no protections regarding eviction. A landlord in this situation can give you no notice at all and tell you you have no time to pack and leave before they can call the cops if they want to have you arrested or removed from the property for trespassing. You have no right to a reasonable notice for eviction. This is a situation the cops will come and respond. They will be considered trespassing if you refuse to leave. There's no recourse under the Residential Tenancies Act. There's no hearings, etc. They can try to keep your rents paid. You cannot seek redress from the RTA for this. You must file a small claims court filing. So this is great for them because most people won't bother because there's all the fees involved and then legal fees if you get a lawyer, etc. If you lose, you're out all that. If you win, you can get that. You can get compensated for all that and your rent back. But most people will not bother, especially if you're low income, which a lot of people who are renting rooms probably are. And that's the end of it.